Hi, good afternoon, everybody. Thank you all for joining us today for our March webinar series on nursing home protection. For those of you who are joining us for the first time, my name is Amanda Sylvia, and I am the Client Service Associate for Stonehearth. I've been with the firm for about 4 years now, and my primary role includes client service, marketing, and compliance. I just want to start off with a few housekeeping items before we get started. On your GoToMeeting taskbar, you should see a section titled Questions. Please feel free to submit your questions throughout the course of the webinar. I will be monitoring them all, and I will ask David to answer as many as time allows at the end of the webinar. If we do happen to run low on time and we are unable to get to your question, David or myself will reach out to you directly after the webinar to make sure that we do get your question answered. Now I would like to introduce our speaker for today. David joined our firm back in 2016 as a senior financial advisor, bringing with him over 20 years of experience in financial planning and wealth management. And prior to joining Stonehearth, David most recently spent 10 years at Commonwealth Financial Network, and he assisted over 1,500 advisors nationwide with complex financial planning solutions and building comprehensive wealth management plans for clients. He continues to bring this expertise to our firm by conducting portfolio reviews with our clients, co-managing client portfolios, and building, analyzing, and maintaining comprehensive financial plans. David also serves as a member on our firm's investment committee. David, thank you so much for joining us today.
Well, thank you, and welcome everybody. Good afternoon. I'm glad you could join us for this next installment in our series where we like to tackle a different topic every month. So we're excited to bring this next topic to you today. It's a question that we get quite often here at our firm, and it's a very important topic to help people with because there's a pretty wide landscape of information for this topic. So it can be hard for the average person to navigate through all of the rules and regulations that are associated with this topic. And the other important part of it is, and you'll hear me say this throughout the presentation today, is that there's a very strong financial application to the topic that we'll talk about today as it relates to trying to conserve your assets and not have them recovered by nursing home costs. But there also is a very heavy legal application to all of the subject matter that we're talking about today. So with the information we'll cover today, we'll go over ideas and topics to be mindful of when you're dealing with this important subject matter. But it's always important to work with legal counsel in this area to implement any of the strategies that we'll talk about. So we're excited that you're joining us here today, and we'll jump right in to our topic. So the real crux of what we'll be talking about today is ways in which nursing home care can be paid for. I think many of you know that the cost of all healthcare has been skyrocketing lately, and the cost of nursing home care has gone right along with that. So when we look at available options to pay for nursing home care, we can look at a few different ways that this can be done. So you can private pay for your nursing home care just using your own assets and income, and some folks have the resources to do that. You can also look at long-term care insurance policies that can provide the ability to pay for some or all of one's nursing home costs, depending on the type of policy that you get. And then there's also Medicaid, or otherwise known in Massachusetts here as Mass Health. And a lot of what I'll be talking about today will be focused on some of the Massachusetts rules, because that's where we are. But it's important to recognize that the rules are different in all states. So when researching these Medicaid application rules in your state, it's important to be aware of those rules. And again, working with legal counsel that's familiar with those rules in your home state is really the best way to go. So Medicaid is really one of the few resources available to help pay for long-term care services, as I mentioned. And what it is, it's a joint venture between the federal government and the states, and it's available to families and individuals with limited resources. And as a result of Medicaid's joint venture status, some of the eligibility requirements and rules and regulations are going to vary between the states, as I mentioned. So therefore, some of the strategies that work in one state may not work in another state. So you'll want to be aware of that. And each state will administer its own Medicaid programs based on the broad federal guidelines and rules. So within these guidelines, each state will determine its own eligibility requirements. They'll prescribe the amount and duration and type of services. They'll choose the rate of reimbursement for services, and the states will oversee its own Medicaid program. So my goal here today is to share with you some of the more popular strategies, and that the rules change rapidly, so please don't attempt to implement any of these strategies discussed today without the assistance of elder care legal counsel within your home state, as I mentioned. Otherwise, you really could be putting someone's life savings at risk, and nobody wants to do that. So we will not be discussing any specific recommendations today, since everyone's situation will have a unique set of facts and circumstances, but instead we'll share information with you that's important to be aware of with Medicaid planning in general. So the other thing to be mindful of is constructing a Medicaid plan should also be done with the eye towards estate planning and income tax goals overall. Let's look at some of the eligibility requirements for Medicaid benefits. There's really two primary areas that Medicaid looks at in order to determine if you're eligible for benefits. The first is the Medicaid applicant's income. So most states have charts that illustrate the maximum income limits to meet the eligibility requirements. However, don't worry if your income is over the limit, because they typically back out a handful of expenses, making it a little bit easier to qualify. And as a general rule, if the nursing home costs exceed your income, then you stand a good chance of being eligible for Medicaid. And any income that a Medicaid applicant receives is counted. So the income can come from any source. For example, it could come from employment wages if that person's still working, alimony payments, pension payments, Social Security benefits that you might be receiving, IRA withdrawals, or dividend from stock portfolios. But when only one spouse of a married couple is applying for Medicaid, only the income of the applicant is counted. So income of the other spouse is not counted when applying for coverage. But a very important and beneficial fact for married couples is that, as I mentioned, the income of the healthy spouse is protected and not considered when someone is trying to meet those Medicaid income requirements. So the other important part is the healthy spouse is not required to use their income to pay for the Medicaid recipient's care. So two important parts there, just to review. The healthy spouse's income isn't counted when applying for Medicaid, and that healthy spouse's income is not expected to be used to pay for the Medicaid recipient's care. The other part is the asset eligibility requirements, which are a bit more complex, but it's also where most of the Medicaid planning opportunities come from. So unlike the income eligibility requirements, the asset eligibility requirements do look at both spouses' assets. In 2019, the Medicaid applicant is only allowed to have up to $2,000 in countable assets. And if married, the healthy spouse is allowed to keep $126,420 of countable assets. So that's a number that is subject to change each year. It goes up $2,000 or $3,000 or so each year based on inflation. That's the limit set by the federal government, the $126,420. So some states may use this amount, such as here in Massachusetts. We use that upper end limit. However, some states may elect to use a lower figure. So there are a number of states that don't go up to that federal limit. They'll only require the healthy spouse to keep a smaller amount than the $126,420. So most assets are countable, but there are a handful of assets that are excluded or maybe referred to as non-countable assets. These would be the primary residence. In most cases, it would include one car, any prepaid funeral costs, and some personal belongings like clothing, jewelry, furniture, things like that, and a small amount of life insurance is not counted as well. An important area that Medicaid recipients or their families should plan for falls within this area referred to as recovery. So a state recovery is when Medicaid tries to recover their expenses after the Medicaid recipient passes away. So most states will accomplish this by obtaining a reimbursement from anything that is probated. So the key is to avoid a state recovery is to avoid probate. But not every state defines the estate in the same manner. So some states will use an expanded definition of someone's estate, which means they go after non-probated assets as well as the probated assets. Here in Massachusetts, we currently use the more restrictive definition of focusing just on the probated assets. Remember that the goal is to qualify for Medicaid benefits, and to do so, you need to meet both the income and asset eligibility requirements. So let's take a look at some of the methods to meet the income requirements. I'm going to be structuring most of the next items that we'll talk about as it relates to a single person being able to qualify and married individuals being able to qualify as it relates to the income and asset limits. So looking at trying to meet the income requirements, there's not really much you can do as a single person or widow or widower. Your income is really expected to be used to pay for your care. So not much we can do there to shift the income. For married individuals, as we said a moment ago, the healthy spouse's income is not part of the equation when it comes to qualifying for Medicaid benefits. So therefore, any income that can be shifted to the healthy spouse should be considered. And each state recognizes that the healthy spouse will continue to have their own living expenses, and as a result, the healthy spouse is allowed to receive a minimum spousal needs allowance. That amount is subject to change. The current amount is set to be between the dates of July 1st, 2018 through June 30th of 2019. Those limits are always set between those dates each year. That minimum current amount is $2,057.50. So if the healthy spouse's monthly income is below that amount, then he or she is allowed to keep some of the Medicaid recipient income to meet that minimum. So, for example, if let's say John is the healthy spouse, his monthly income is $1,500, then he can keep an additional $557.50 from Jane's income, and Jane is the one that's on Medicaid. So there is an opportunity there to shift some income. And also, Medicaid agents do have some discretion. So filing a hearing to plead your case as to why the healthy spouse may deserve to keep even more of the Medicaid recipient's income could be an appropriate course of action if the healthy spouse has high living costs. For example, let's say John has a mortgage on the house for about $2,500 per month. John may be awarded a little bit more of Jane's income to help with that mortgage and the other living expenses. So important to remember that there is some discretion amongst the treatment of this from state to state. So let's look at strategies to meet some of the asset requirements. When a senior is applying for long-term care with Medicaid, whether that's for services in one's home or assisted living residence or a nursing home, there is an asset or a resource limit. So in order to be eligible for Medicaid, one cannot have assets greater than whatever that limit is. And as I mentioned, it does shift and increase year to year. So Medicaid's look-back period is meant to prevent a Medicaid applicant from giving away assets or selling them for under fair market value just in the attempt to meet the Medicaid asset limit. So one easy way to meet the asset eligibility requirements for Medicaid would just simply be to give your assets away to a non-spouse or an irrevocable trust. Note that living trusts or a revocable trust don't work for Medicaid planning. We'll talk a little bit about that later. So one way would be to just simply give away assets to get below that $2,000 limit, but unfortunately, it's really not that simple. Medicaid will ask you on the application if you have made any gifts or transfers within the last 5 years. So that 5 years is known as the look-back period. So if you have made any gifts, they'll apply a penalty period based on the amount that was gifted or given away. And during this period, you'll not be able to receive any Medicaid benefits. So the penalty period does not begin until you would otherwise qualify for benefits. So it doesn't necessarily begin on the date that you gifted an asset or gave it away. It's going to start on the date that you otherwise qualify for Medicaid benefits. So that might be a stretch of time in between you've given away some assets and you would otherwise qualify for Medicaid. So it's important to note, though, that transfers between spouses are not subject to the look-back period or the penalty period. So the challenge here is that you have to give away assets 5 years before you apply for Medicaid benefits, and most of us just simply don't know when that will be. But if you have more assets than you need to fund your retirement, then it might make sense to start gifting the excess amount now, just in preparation for this. On the other hand, if you think you need all of your money and you may not have this luxury, then you'll need to rely more on what would be called crisis planning or planning later on when you're about to need long-term care services. So the date of a person's Medicaid application is the date that one's look-back period begins. So as I mentioned, in most states, actually in 49 states, that look-back period is 5 years or 60 months. California happens to use a shorter look-back period of only 30 months, but the other 49 states will use 5 years. So as an example, if a Massachusetts resident applies for Medicaid on January 1st of 2019, then their look-back period extends back 60 months to December 31st of 2014. And then all financial transactions during that time period are going to be subject to be reviewed. So the penalty is really a period of time during which the person transferring the assets will be ineligible for Medicaid. And the penalty period is determined by dividing the amount transferred by what Medicaid determines to be the average private pay cost of nursing home care in your state. So a lot going on there, but as a example, if you live in a state where the average cost of monthly care has been determined to be $5,000 and you give away property worth $100,000, you'll be ineligible for benefits for 20 months because you take the $100,000 that was given away, divided by $5,000, which is the average monthly cost of care in your state, and that equals 20, so that's 20 months of a penalty period. And that 20-month period does not begin until the person making the transfers has moved to a nursing home, has spent down to the asset limit for Medicaid eligibility, and has applied for Medicaid coverage, and lastly has been approved for coverage except for the fact that they made that transfer. So, for instance, if an individual transfers $100,000 on April 1st of 2016, moves to a nursing home on April 1st of 2017, and then spends down to the Medicaid eligibility limit on April 1st of 2018, that is when the 20-month penalty period will start, and they'll not end until December 1st of 2019. So in Massachusetts, we actually use a daily benefit, which is subject to change each year. So that the average cost of the daily benefit for care is $366 as of November 1st, 2018. That new limit was set. So using those same numbers, if you were to give away $100,000, you divide that by $366 to get about 273 days or about 9 months. So that's the way it would work. Some states will use an average daily benefit, some will use a monthly benefit. So some examples of the transactions that could result in a penalty include money that was gifted to a granddaughter for high school graduation, or a house transfer to a nephew, or some collector coins that you might have that you sold to someone for less than fair market value, or even a vehicle that was donated to charity. So you have to be careful about some of those transactions that can bring in that penalty period. So let's continue to look at strategies on how you may be able to meet those asset requirement limits. There are ways for one to spend down excess assets without violating Medicaid's look-back period, and therefore you can avoid the penalty that would be imposed. So the following strategies are all ways that someone can do, but the look-back period is extremely complicated, so it's highly recommended to, as I've mentioned before, to work with a Medicaid planner using one of these following strategies. So for a single individual, the primary residence, as I mentioned, is one of the non-counted assets. Currently in Massachusetts, the limit of equity one can have in their primary residence is up to $878,000 for 2019. Again, that amount will increase a little bit each year. So that amount is of equity in a home is non-countable. So as a result, the home is really a very rarely a hurdle when applying for Medicaid benefits. But however, a lien may be placed on the property after becoming eligible for Medicaid benefits so that the state can recover their expenses. So one consideration is it's usually not a good idea to sell the house because it takes it from a non-countable asset into a countable asset. So if you sell the home and now you have proceeds from the home, those proceeds that you're holding as cash or invested assets, those are going to be counted. But as it exists as home equity, it won't be counted up to that $878,000. So Medicaid recipients are allowed to keep up to $2,000 in assets for their 2019 limit. So one can also use assets in excess of Medicaid's eligibility limit for home modifications and repairs without violating the look-back period. So this would include maybe replacing old plumbing systems, updating electrical panels, maybe adding a first floor bedroom and or bathroom, installing things like wheelchair ramps or chair lifts, widening doorways to allow for wheelchair access, those types of things. Also, paying off debt such as a mortgage or credit cards is not in violation of Medicaid's look-back period and can really effectively lower one's assets. So let's now turn to looking at how married individuals could meet asset requirements. Many of these are going to be the same things that we talked about. As we said, the primary residence is not counted, so we're really not too worried about that. The Medicaid applicant can keep $2,000 in assets, but now that we're talking about married couples, we can also talk about the healthy spouse being allowed to keep up to $126,420 in assets. So combined, that totals $128,420 of assets for married couples that they can keep and still qualify. So if you have more in assets, then you can consider some of the same ways to spend down assets that we just talked about. Maybe some renovations in the home, or maybe it could be upgrading the car, or prepaying funeral expenses for both spouses, or buying a new TV, or as we said, for single people as well, paying off some debt. So 5 years in advance of applying for benefits, you can really consider making a disqualifying gift to a irrevocable trust or somebody other than your spouse, but this will be subject to a penalty period if done within the last 5 years. But if you're able to make those gifts and you can get through that 5-year period, then they won't count as part of the look-back period. So as we said, healthy spouses are allowed to keep 100% of their income. So one consideration can also be using some of the excess assets to purchase an annuity, which will turn assets into income for the healthy spouse. And as we said, the healthy spouse's income isn't counted, so they'd be able to use that. But it's important to note that each state has their own rules for these Medicaid annuities. So not all annuities may be Medicaid compliant. So when considering the annuity option, you really have to proceed with caution and make sure you're getting proper legal advice. And as I mentioned, scheduling a hearing with a Medicaid agent if the healthy spouse feels that they need additional assets beyond the $126,420 is possible. As I said, Medicaid agents do have some discretion on how they can handle each person's individual application. So we also talked about the estate recovery, and that's when the Medicaid recipient passes away and the states are looking to recover some assets from the estate. So there are some strategies to try to reduce or even eliminate the recovery of certain assets by the state. So again, starting with a single person, if the Medicaid recipient's sole name is on the house, then the state will likely recover their expenses because assets in your sole name will be likely to be probated after you pass, so they'll be subject to be recovered. Avoiding probate will reduce the chances that Medicaid will recover their expenses in those states that do only focus on the probated assets. So some ideas and strategies to reduce or maybe eliminate the recovery would be to transfer the home to a child who moved into the home and provided care to that parent, which kept the parent out of the nursing home for a period of 2 years. If that strategy is done, then that transfer is not considered a disqualifying transfer. So a child can move into the home, and as long as they're there for 2 years providing care to the parent, then the rules look at that and say, okay, you help to delay that parent going into a nursing home for those 2 years, so we're not going to recover the house for that reason. If the home is going to be subject to the estate recovery, you could consider renting the property to generate some income that can help defray some of the costs of the nursing home. And that means that Medicaid would be spending less, hence they'd be recovering less. Also, if the Medicaid recipient has a long-term care insurance policy that has benefits of at least $125 a day for a period of 2 years, then Medicaid will not pursue the recovery of the primary residence. So in most cases, any long-term care insurance that we'll talk about with our clients will make sure that we provide at least that amount of daily benefit in the policy so it'll qualify for this rule. Another strategy to look at is 5 years in advance of applying for benefits. You could consider gifting the property to your intended heirs while maintaining a life estate, which gives you the legal right to live in the property for the rest of your life. But you'd still be subject to liability risks, from the kids if you gifted it down to the kids. But these potential liabilities are really deferred until after you either sell the house or pass away. But maintaining that life estate ensures that you would retain the ability to live in the house for the rest of your life. The other strategy would be, again, 5 years in advance applying for benefits. You could consider gifting property to a irrevocable trust, a Medicaid planning trust, and this will help to avoid the asset going into your own probate. And over the last couple of years, though, Medicaid has been kind of poking holes in some of this Medicaid planning, including the use of irrevocable trust. So again, important to revisit this strategy with an elder law attorney in your state to ensure that the structure is still appropriate. Other assets, not really much that can be done. The single person has to get their assets down to that $2,000 limit. So looking at strategies to eliminate or reduce the estate recovery for a married individual, again, that person could consider transferring 100% of the ownership of the property to the healthy spouse. Remember, transfers to spouses are not a disqualifying transfer. So you're able to transfer assets from one spouse to the other. So for states that focus only on probated assets, this will prevent the property from flowing through the Medicaid recipient's probated estate when they pass away. So in those states that use an expanded definition beyond just the probated assets, this strategy of transferring the home to the other spouse may not work. So again, you'd want to be aware of that. As far as other assets, you could consider transferring 100% of the ownership of the other assets to the healthy spouse. As we said, those transfers to a spouse are not a disqualifying transfer. So, for example, that could mean just changing an account that's held as a joint account to a individual account in the healthy spouse's name. So let's take a minute or a few minutes here and look at a couple of different case studies just to help to illustrate some of the points that we've been talking about. So in our first case study, we'll look at Sheila. So Sheila is a widow. She's 80 years old. She has a couple of kids. She lives in Massachusetts, and she's relatively healthy. She has a couple of income sources from Social Security and pension. As far as her assets, she considers herself to be living in her forever home, which is helpful. For someone who's not considering selling their home, there's a little bit more planning that comes into play when you're in your forever home, so to speak. And she has bank accounts of $250,000, and she has a car with a current Kelly Blue Book value of $25,000. So continuing with this strategy, we can look at some things that Sheila might be able to do in preparation for qualifying for Medicaid. She could gift her primary residence to the two kids, and again, helping to avoid the recovery of that asset by the state. And as I mentioned a moment ago about gifting the asset down to heirs, gifting your home but maintaining a life estate, the way that the rules work is when you gift that asset, you're not considered to be giving a gift of the entire amount of the value of the home. When you maintain a life estate, you're considered to have been retaining some value of your own because you get to live there for the rest of your life. So there are government tables that help you determine how much of that gifted house was actually a gift down to the beneficiaries and how much are you considered to be retaining out of that asset. So the way the government tables work is you look at a person's age. In this case, Sheila is 80. So it's determined that she's keeping a little over 43.5% of the house as the life estate value, or in this case, $218,295. The balance, the $281,705, is considered to be the gift to the kids. So she just simply files a gift tax return for that amount, and no taxes are owed. She can apply that gift to her lifetime exemption amount. She's not really interested, however, in gifting the bank assets because she thinks she'll need that to supplement her income needs for now. So now let's fast forward 5 years. 5 years later, Sheila is now 85. She's had a stroke. She needs nursing home care. So as we said, her income sources total $2,700 a month. Her assets 5 years later, the bank assets have gone down to $200,000, but she's only allowed to have $2,000 under the current rules to qualify for Medicaid. So now we're looking at spending down $198,000 to get her to that point for her asset level. So how might we be able to look at different ways of spending down those assets to get her down to the $2,000 limit? Well, we talked a moment ago about different things that you can spend on home repairs and other things. So let's take a look at what Sheila did here. She spent $30,000 on a new septic system. It was something that was going to be needed on the house anyway, so she was able to spend down assets to do that. She also got a new car because the kids are going to have to take mom to and from doctor visits, so spent some money on a new car. There was a $10,000 trade-in on her current car and another $20,000 out of pocket. So there was another $30,000 spent there. She spent $1,000 on a new TV and another $5,000 to prepay funeral expenses of her own. So when she goes to apply for Medicaid, the primary residence is not counted. The life estate, the gift was made over 5 years ago, so there's no penalty period. So that gift of that home and the life estate would be subject to a penalty period, but in this case, 5 years have passed, so we're not worried about that. Her income is used towards her nursing home expense. Remember, we talked about for married couples, you can do some things with income, but as a single individual, her income is expected to go towards her nursing home care. And then the remaining assets, after we spent down some assets, the $142,000 is used to pay for cost of her care. So that's approximately 14 months or so. And once those are used up, she can apply for Medicaid benefits. So looking at implementing those strategies, some of the benefits that Sheila was able to realize is she was able to pass on a house to her heirs, which is now valued at about $600,000. She sheltered some assets where we spent down the $56,000 on various things of home improvements and the car and so forth. And because the house and the car are owned jointly, they won't go through her probate, so there's no estate recovery on those. So really, we've achieved a savings of about $600,000 for the house and about $56,000 on the assets that were spent down on various things. So we can see the effectiveness of implementing those strategies in this case. So it's often thought of that married couples do have more options available to them with planning, but as you can see here with Sheila, there still are some things that a single person can do. Speaking of that, let's look at our second case study where we look at a married couple and take a look at some of the strategies that they can implement. So let's look at John and Jane. They're happily married for 55 years. They have 3 children. They're 82 and 80. But sadly, John's health is failing a little bit, and Jane can really no longer take care of him. So John is starting to prepare to enter a nursing home. So we're getting into a little bit more of a sort of a crisis planning type of situation where the nursing home needs are imminent, and we're not looking at being able to get through these 5-year periods. So John's income is Social Security of $2,500 plus $2,000 a month for pension, and Jane's income is $1,250 per month. For assets, they've got a home valued at $700,000, which is owned jointly. They live here in Massachusetts. The bank accounts are worth $400,000, also jointly owned, and they own a car that's currently valued at about $10,000. And for an estate plan, they've got simple sweetheart wills. So looking at some strategies that we might be able to help John and Jane with, we can first take a look at the home and transfer the home to Jane. So we get the home just solely in Jane's name. We do the same thing on the bank accounts where we take those out of joint ownership and put those solely into Jane's name. Jane has power of attorney over for John, so she's able to do these things. And we end up updating Jane's will to leave everything to the 3 kids. So let's look at excess assets now. We said their assets are $400,000. So we know that we can subtract $200,000 because John's able to have assets up to $200,000 as the Medicaid applicant. We can subtract another $126,420 because Jane, as the healthy spouse, is allowed to keep that amount as per 2019 limits. So that totals $271,580 that we're now looking at. We can start to implement some of the spend down strategies that we looked at earlier. And in this case, we can spend on a new heating system, a new roof, again, buy a new car, a new TV. We can prepay funeral expenses for both of them. So with all those items, we've spent down another $56,000. So that leaves $215,580 above the Medicaid eligibility requirement. So that new excess of $215,580, what are some other things that we can do there? Well, we can consider gifting and annuity contracts to help in this type of situation. So let's assume we give a gift of $115,580. As I said, we're into a crisis planning here, where John is not going to be able to get through the 5 years to his application. So that gift of $115,580, subject to roughly 13 months of a penalty period. So that he's given that gift to the kids, and we have to get ourselves through a penalty period. Again, that'll vary by state, but in this case, roughly around 13 months for Massachusetts. And then we take another $100,000 and we purchase a SPIA, or a single premium immediate annuity. And what we do there is we turn that $100,000 of assets into income for Jane. And as we said, Jane, as the healthy spouse, is able to keep her income. So we're going to get approximately $600 a month from this annuity by turning the $100,000 of accountable asset into a annuity income stream for Jane. So now we've taken the $400,000 that we started with. We subtracted $115,000 on gifts to the kids, $100,000 that went into the annuity, another $56,000 that we spent on various spend down strategies, and we get down to the $128,420, which is the exact amount that they're able to keep. The $126,420 for Jane and the $2,000 for John. So we get to that $128,420 limit. John then applies for Medicaid. The house is non-countable, so we're not worried about that, because we said the equity in the home was about $700,000, so it's underneath the present limit for Massachusetts, so they're okay there. They do have that penalty period for that gift that they made to the kids, so we've got to get through 13 months for that. So they're looking at privately paying for John's care for those 13 months. And then in 13 months later, the Medicaid benefits begin. Now, we talked earlier about some of the income levels that are part of Medicaid applications. And we said that the minimum spousal needs allowance is $2,057.50 per month. So Jane is getting $1,250 from Social Security. She's also getting $600 from the annuity contract. So she can keep another $207.50 of John's income that can be shifted over to Jane. So Jane does not need to use any of this for John's care. So in this case, Jane's income was below that minimum needs allowance amount, presently at $2,057.50. So we were able to kind of shift some of John's income over to Jane under these current guidelines. So it's an effective way to move some of that income that would otherwise been spent on John's care over to Jane. So the balance of John's income will go to nursing home costs, but we essentially protected $271,580 through gifts, annuity, and spend down strategies. And the home now should be protected from estate recovery since it will not pass through John's probate estate, potentially protecting another $700,000 asset or whatever that asset might be later on. So again, we looked at different ways that married couples can implement some strategies to help protect some income and some assets. So really just looking back to what I said at the top, where we wanted to just look at some general strategies that people can implement to help them, whether you're single or married, just to protect as much income and assets from being used for nursing homes. So again, just to wrap things up here, we really weren't looking to provide a list of all available strategies during our discussion today. It was just really looking at some of the more popular strategies that can be implemented, just so you can get an idea of the effectiveness of some of these strategies and what they can potentially do. So nothing that we discussed today is, again, not a specific recommendation to anybody, but any recommendations that come from this type of planning should come from a qualified elder care attorney who specializes in this area and who also specializes in the rules associated with your home state. So that's very important. You know, and as I mentioned earlier, the rules and regulations are just really very fluid, and it's hard to rely on you know, anyone to give qualified advice unless they're, you know, spending every day in this area. That's why attorneys who specialize in this area tend to only do this as part of their area of practice. So you really want to do this type of planning in conjunction with the rest of your financial plan as you look at estate planning or income tax goals. So we need to look at the entire financial plan when it comes to this area and making sure that you're getting proper legal advice. So with that, I thank you for listening, and I'll wrap things up and turn it over to any questions that might have popped up during the session.
Hi, David. Thanks so much. Yeah, so just as a reminder, if you take a look at your GoToMeeting taskbar, there is a section that says questions, so feel free to enter those as we go through this questions section, and we'll do everything we can to get to everyone today. So David, the first one I have says, is rental income considered, or is pension and Social Security only looked at?
Yes, rental income is also considered. So I guess a good way to look at it, excuse me, is if it's income coming to you and you're the Medicaid applicant, then it is counted. So yes, rental income would be counted.
Okay, the next question I have is if you could briefly explain testamentary trusts and how they might play a part.
Yeah, that's a good question. Testamentary trusts can be used in situations where an individual, maybe through their will or through adjusting their beneficiaries, can leave assets to a testamentary trust, avoiding accountability as probatable assets, and the assets that go into the testamentary trust would go to beneficiaries. So it can be an effective use in Medicaid planning because you can remove those assets from your probate estate and thus help with the recovery of those assets by the state.
Okay, I do have just a couple more. Are my assets safe or protected from Medicaid in a revocable living trust?
Yeah, that's a good question. Fairly popular question. The answer is no. So a general rule of law in this area basically holds that whatever you can access, others may access as well. And assets in a revocable living trust are open and available to you. Therefore, they're also open and available to Medicaid, and therefore you would be disclosing those on the Medicaid application. So revocable living trust, as the question asks, is not a way to protect assets. Irrevocable trusts do provide some planning in this area, however.
The next one I have is, if I hold joint accounts with my children, are they safe or protected from Medicaid?
No, they're not. So Medicaid will treat any asset with your name on it as yours. So joint accounts would fall under that, as I talked about in the presentation, where we talked about shifting some joint accounts over to the sole name of the healthy spouse who's not applying for Medicaid. So the only time a joint account may not be counted, and this might be hard as far as the burden of proof being on you as the Medicaid applicant, is if you're able to overtly prove that the joint owner, so the person other than yourself, was the only individual to actually contribute all of the assets to the account, and your name is just simply on the account as a joint account owner. If you can prove that the other joint owner owned all the assets and put those into the account, you might be able to get away from those assets being counted. But as a general rule, you would want to plan on jointly held assets to be counted as your own.
And it looks like we just have one more here. What are some good website resources to read and maybe research Medicaid rules when the time comes?
Yeah, there's a lot of great resources out there online for this subject matter. So some websites that I like are, making sure that you're getting reliable information. The federal government's website on this topic is Medicaid.gov. And it's the federal website for Medicaid, but there is a link in the top menu entitled State Overviews, so you can get a chance to drill down a little bit into information on individual states by going into that State Overview section. But as a website with general federal guidelines on Medicaid, the Medicaid.gov is a nice resource. Also here in Massachusetts, mass.gov, mass.gov, is a place where you can start, and on the homepage of mass.gov, you can put Medicaid into the search field right on the homepage, and it will get you over to Mass Health, which is what Medicaid is referred to here in Massachusetts. And lastly, there's a nice website resource which is called elderlawanswers.com. And that's got great info, and also it will help you to find attorneys who specialize in this subject matter in your area. So elderlawanswers.com, great resources to research the topic, but also a really nice place to find qualified attorneys in your area that specialize in this subject.
David, I think that's it. Thank you so much for all this information. I just want to remind everybody that's on the webinar today, if you head over to our website at www.stonehearthcapital.com, you can go ahead and under resources, click White Paper Archive. David did go ahead and write a white paper that does correspond with this webinar for today. It does, I believe, go into a little bit more detail. Also, to continue our webinar series, we're doing CIO's Corner, which is a quarterly update with our Chief Investment Officer, Chris Gauthier, which is next month for April on the 29th at 10 a.m. You can also go ahead and sign up for that on our website as well. So thank you so much for joining us this afternoon. David, thank you, and I hope everyone has a great day.
Thanks very much. So long, everyone.